Good morning. Please be seated. Thank you. This is the time set for oral argument on our case entitled Beal Properties. I don't know if I'm pronouncing that correctly. Beal Properties and many others versus CRG Partners and others. Our cause number CA CV140186. We have reviewed the arguments and issues. We have conferenced the case. We're prepared for your argument. We'll probably have some questions. Each side has 20 minutes. If appellant's side wants to retain some time for rebuttal, you need to watch the clock and take care of it yourself pretty much, and we'll try to cooperate with you. And we need you both to, whoever's arguing, to state your name for our recording, please. And having said that, then we're ready for appellant to begin. Is it Mr. Stratman? Is that?
Yes, sir.
Have at it.
Thank you. I'm going to try to reserve 5 minutes for
very well.
rebuttal. Your Honors, what I'm going to do here real quickly is I'm just going to do a quick intro.
We have a question for you, I think, coming out of the gate,
Yep.
which may tell you how much time you're going to get to save. But go ahead. We need it.
I don't have a question, but they
We need a
do.
clarification.
Yes.
You're representing Beal, right?
Correct.
Okay. In looking at this, we noticed that there were two bankruptcies.
Mm-hmm.
Kelly declared bankruptcy, and that was dismissed without a discharge.
Correct.
And RDP filed bankruptcy, and we cannot tell from the docket in the bankruptcy court. We know that it was closed. The bankruptcy case was closed. But my understanding, and so I'm wondering what happened in the bankruptcy court, because at least I don't dabble in bankruptcy.
Yep.
No one should dabble in bankruptcy. They should either be a bankruptcy attorney or not. But my understanding is that while a bankruptcy petition is pending, there's an interlocutory stay on against all other actions. And after the bankruptcy decision is entered, unless it's been dismissed, there is a permanent injunction stopping creditors from coming after doing anything that could against with the bankrupt. But in 30 years of the legal profession, one of the first things I learned was you don't step on the toes of a bankruptcy judge. So my question is, what happened in the bankruptcy, and can we allow this appeal to proceed?
Yes. Yes, it's my understanding. I don't want to cut you short. I'm sorry.
Oh, go ahead.
It's my understanding now that RDP, who declared the bankruptcy, although that case is now closed, I don't believe there was a discharge for whatever reason, but RDP actually is no longer the alleged owner of that property. There is a new entity called Monte Vista who has taken title to that. So after our judgment, or after they obtained a judgment, or shortly beforehand, there was a successor entity that took title to that property. So RDP is not really in the mix for the quiet title.
But it's still a party to this case.
So it's not on title, for lack of better words, and so they're no longer relevant in this
But
case.
it's still a party to this case.
Correct, Your Honor. Their name
have
is
anything? Do we have anything saying that RDP is not subject to a judgment in any fashion that we hand down from this court, given the fact that they are the party to this appeal?
Sure. I mean, the bankruptcy case, there was only one thing filed after the judgment was entered in this case. They eventually filed bankruptcy. The trustee said there was no assets up front, and the case had been waiting to be closed, and it's my understanding there was no discharge, and it was closed at this point. So that was the only thing that was ever filed in that case.
But for us, go ahead, I'm sorry.
Was there an order from the bank? You know, the problem is when we got into the bankruptcy docket, to be candid, we got into the bankruptcy docket. Well, the last thing we found, as I understand it, was filed on February 3rd, which was closed. And when we tried to open that to see what it meant, we couldn't open it.
Likewise,
So,
Your Honor.
I mean, it would probably help us if the parties could file something with us about the orders in the bankruptcy court so we could determine if we need any further clarification from the bankruptcy judge about whether this case can proceed?
Because it's my understanding it is closed now.
Right, but I mean,
Sure.
we need something that would show us what happened, and then we can make a decision about whether we need to order the party, whether we need to stay it pending further clarification.
Sure.
If you would, counsel.
Okay, so we will do that. We'll get the record from the bankruptcy court and get something to you right away.
Thank you.
Okay, with that said, Your Honors, this case on paper is obviously a quiet title case. Parties disputing ownership, but it's much more than that to my clients, Your Honor, the appellants in this case, some of which are back here. You basically have 15 to 17 individuals or entities that invested their life savings, their retirement funds, instead of in the stock market, in this project. Okay, they were supposed to get a 10% return to 15% return. Never got any money back because there was never any payments by RDP, the borrower under the loan agreement, which I'll get into. Instead, because there was no payments by RDP under the loan agreement, they have to go try to get their money back from the property. And unfortunately, because of the trial court's ruling, in this case, now they can't even get their money back from the property, which is a collateral that secured their investment. And so we're here.
The trial court's ruling, are you referring to the default judgment?
No, we're referring to the appellants don't have standing to bring a quiet title claim for ownership of the property.
Well, that
As
relates
a-
to the default judgment.
Correct. Yeah, I thought he said the default judgment. I'm sorry.
That's what I meant.
I did.
So, okay.
It relates to the default judgment. The default judgment basically said, as I understood, let me just understand the argument. Your client's position was, since the money was lent out and there was a trustee sale, we take the place of foundations. Fair enough?
Because we had assignment and became a beneficiary under the trust.
And the
Correct.
trial judge entered a judgment, a default judgment, that said that trustee sale's no good.
Correct. After they entered a judgment against, after they made the ruling.
No.
No, they made the ruling. Yes, there's a judgment.
There's a default judgment, right?
Yeah, correct.
Filed on October 28th, 2013,
Correct.
that says the trustee sale is no good.
Yes. And then they have our judgment. Correct.
And then you have your judgment. So that judgment's in place. The basis of your deal and your clients, the investors, is we have an interest in the property because there was a trustee sale and we had an assignment. But the trustee sale says it's no good. I mean, the default judgment says that trustee sale is no good, and therefore the deed of trust, the trustee's deed, is quashed or stricken. And how can you have, so your assignment is an assignment of nothing.
But the default judgment that they got against, which was actually the default was entered into before our case was even filed, but the default part of it, not the judgment. But that wasn't. They're basically arguing collateral estoppel that should somehow bar us from litigating.
And the cases were consolidated, correct?
They were consolidated.
Were consolidated.
Correct, but after they were defaulted. After they were
Not
defaulted.
after, but for the default judgment.
Correct. And
So they're consolidated before the default judgment, okay? And the judgment gets entered, and nobody does anything.
But we weren't a party to that default
But it
judgment.
was consolidated. You could have asserted your right before the judgment to say, wait, judge, don't enter this default judgment because we have an interest.
And we did object to early on default judgments. We had done that. We got it postponed 3 times by entering an objection, which is on the record back in
Fine.
back in the time. So we did
But
that.
if you're not a party to it, your objection isn't really very
Yeah,
strong.
well,
But then
exactly.
why didn't you appeal? And say, wait a second, we filed these objections and the court wouldn't listen to us, and we have an interest.
Because we weren't a party to that judgment.
How can you file an objection to it?
You were party to the litigation.
We were parties to the litigation, correct. And so,
You were in the combined action.
correct. But that issue was not litigated, so we litigated our issue, which turned out to be a different judgment. And so we're contesting that the court couldn't rule on the merits as part of that from a collateral estoppel argument.
But
I mean, that's what they're arguing. We're
My problem
contesting.
is there's a valid judgment out there. There's a judgment that's never been appealed that you could have tried to do something about. Your deal could have tried to do something about that judgment. They were a party to the consolidated case. They filed objections to the default judgment. The court refused to hear those objections.
Correct.
And you could have filed an appeal. And then you could have argued out the standing before the Court of Appeals and said whether you had standing to even bring the appeal. But it does seem to me that the problem now is your argument, in essence, I mean, is trying to collaterally attack that judgment. Because as long as that judgment stands,
But it doesn't stand because it's on the merits, though.
there was no trustee sale.
But it wasn't on the merits, and the case law out there says that a default judgment not on the merits does not allow.
Well, there's a case out of Division 2, Noriega versus Machado, 179 Arizona 348. It says, res judicata, if we analyze this situation that of default judgment, res judicata applies to bar the second action. A default judgment has the same res judicata effect as a judgment on the merits. The issues were litigated. So,
Well, we're arguing that they can't from a collateral estoppel standpoint, since we weren't the exact same
principles
parties.
are the same. The collateral estoppel, the issue.
But the judgment wasn't against us, so we're not going under res judicata. We're arguing that.
Yes, but collateral estoppel, I mean, you could have, res judicata can apply even if you're not a party, if someone would have been, in essence, you're the person asserting your same position.
But there was no one in that.
Foundations could have come in and said, no, don't enter that default judgment. And in essence, they wanted that trustee sale to stay. And so, but I mean, now you're suddenly in the position of saying, we want to collaterally attack that judgment when we could or should have done something other once that before.
But Foundations Commercial, though, wasn't our representative, and we weren't stepping into their shoes. We're separate. They also had an interest in.
You're the assignee under that agreement.
But not all of it. They have a small portion, which is covered like $5,000 or $10,000 or something like that. So we didn't step into. They assigned us the rights to repayment. They didn't assign us to step in their shoes.
Are you saying that you had no recourse under the assignment to defend yourself in this action?
We weren't sued in the action. But we didn't step in their shoes. Sorry.
To present your position, you're saying that your assignee position provides you no standing in this lawsuit?
No, we're saying that we weren't, though, it didn't assign us to where we stepped into their shoes, where a default judgment against Foundations Commercial was a default judgment against us.
But you had a similar interest. Similar interest would have been to try to keep that as a signee or signor. That the interest would be to make sure that trustee sale stood, because that's the basis of your assignment. That's the basis of your claim. And it seems to me that from whether you want to call it res judicata or collateral estoppel issues, if the person who was representing, you're in essence representing the same position, doesn't do anything, gets a default judgment, then you've got a problem. And that's almost like, and therefore it's a collateral attack, especially because, I mean, in essence, you asserted an objection to the default judgment. Default judgment gets entered, and nobody takes an appeal. Nobody seeks to, whether you had standing to or not.
Yeah,
the problem is it's moot at this point because you didn't do anything.
Sure, but there was no standing, which is since we didn't step into their shoes, which is why we're here.
We don't know that because nobody took an appeal.
So,
Sort of, I mean, if you had an independent interest, independent other than the assignment, it's a different issue. But you're basing everything on the assignment. When there's a default, when there's a judgment that says in essence that the trustee sale was no good.
But we're getting hamstrung, and I don't believe we should under the law, by Foundations Commercial selling our clients down the river. I mean, that's essentially
Isn't that really who your cause of action's against?
There is a cause of action against them, of course.
But my point is, you can't go after Foundations now, right?
RDP, are you talking about?
I'm sorry.
Yeah.
On this issue as to the deed of trust, RDP is your target because they can't help you in regard to the problem that Foundations created by the way it handled the whole
Correct. Foundations
trust issue.
obviously was the issue.
And you still have damage claims against RDP.
Yes, we do. We do have damage claims. Well, RDP, we didn't do anything because of the current bankruptcy. But Foundations Commercial, yes, we do. But we also tried the equitable remedy to get the property back.
Right.
But yes, there are, because yes, Foundations Commercial obviously put the clients in this position, which is why we're here. But again, they were a separate defendant as well, and so because they chose to. So yes, we do have damage remedy against them. We actually have a judgment now, but we also were seeking title of the property based on the assignments, which again came through Foundations Commercial, which is why we're here.
You have to get title in this action, or you don't get it.
So
Do you
yes.
have to get title in this action, or you don't get it?
Correct.
Yeah. Now, what about the law that seems to say that if you don't have a right to title,
keep quiet.
You can't bring a quiet title action as opposed to a lien on property.
Well, it went from a lien to title at the trustee's sale because we were the beneficiary under the trustee's, the deed of trust. So that's where it went from a lien to us claiming title. The triggering event was the trustee's sale.
Foundations got titled, therefore, as
But it should have went to us. Yes, that's where our claim for
partial
title is.
S&E, you should have had your name on it somehow.
Yes, exactly.
How should it have went to us?
Because we were the trustee, obviously the attorney for Foundations Commercial conducted the trustee sale. The beneficiary, obviously, once the assignments were in place, went to the appellants in this case. So as the beneficiaries, we should have been named on the trustee's deed.
But you weren't beneficiaries. You were an assignee under the agreement with Foundations.
Once we were assigned the interest in the promissory note, once we were assigned an interest in the rights to the promissory note, the law, Your Honor, says in ARS 33-1817, Vasquez, Rodney, and Campbell, that we are also assigned an interest in the deed of trust automatically by being assigned by.
You have a lienor's interest or a mortgagee's interest, right?
No, we have a beneficiary's interest.
And it says beneficiary. You become a beneficiary, even though you're not named in the deed, even
Yes.
though you're not assigned a beneficiary's interest under the agreement, you are a beneficiary.
Yes, that is exactly what the cases say because it's a secured contract. And then the deed of trust itself mentions that beneficiary's name might not be obviously in the deed of trust itself because it could change.
Have you read the Metcalf case?
Yes.
And doesn't the Metcalf case say that in this case when Foundations if we're going to agree that they got the title to the property, that they simply hold that and you remain the assignee, and they hold that in regard to your lien on the property?
No, because once we became the beneficiary,
Assuming you became the beneficiary.
but we did.
Oh, okay. So we'll assume you became the beneficiary. Go ahead.
Yeah, so we became the beneficiary as a result of those assignments under ARS 33-1817 in the three cases I referenced. And by being the beneficiary, then once the trustee sale occurred, that's when our right to title came about.
So you were the beneficiary before the trustee sale occurred.
Correct. Correct. And it was a trustee who conducted that. And so we obviously aren't objecting to the trustee sale. It's who it went to because Foundations Commercial was no longer the beneficiary after they assigned us their interest to repayment and in the collateral in the assignments. And that's where the case law says when there's a transfer of an interest in a promissory note in a secured contract, and this was a secured contract because we have the deed of trust, we become the beneficiaries under there.
Even if it's a partial transfer.
Correct. It was partial because there was separate investors. So it was partial, but it ended up with a total, essentially, is our understanding. Now, there may be an extra in Discovery 5 or 10,000 out there with Foundations Commercial, but at worst case scenario would be all of them and Foundations Commercial as the owners as a result of the trustee sale, not just Foundations Commercial, which is what happened.
So did you hold, and you've referenced both of these in the last sentence.
Yes.
Did you hold a right to payment as an assignee, or did you hold as beneficiary under the deed of trust? Those are two different concepts, right?
Did we, as the
You had said you had a right to it. Under the assignment. You had a right to repayment.
Correct. Correct.
Are you saying that everyone that has a right to repayment automatically becomes a beneficiary?
No, but because in this case the right to repayment was also secured because there was a secured contract and it was secured by a deed of trust, that's where the statutes in the cases come in that say because we were assigned a right to repayment in that promissory note, we're also assigned a pro rata interest in the deed of trust.
Okay.
Because it was a secured contract. That's what ARS 33-1817, Vasquez, Rodney, and Campbell say. So that's how we get to that position. Then the trustee sale happens, and the deed goes to Foundations Commercial instead of
So why didn't you
the
then
appellants.
come in and try to challenge that?
Well, the challenge on the trustee sale, we weren't objecting to the trustee sale itself. We were objecting to the deed after the fact.
And why didn't you come in when there was a challenge to the trustee sale? Why didn't you come in and say, we think the trustee sale was good, but the deed isn't?
Sure. Well, I wasn't around at the trustee sale time,
I
but
don't mean you,
yeah,
but I mean
sure. But at this point, there's been no transfer from the property from an RDP to a separate purchaser here, so nothing has changed literally from the day of that transfer, the trustee sale. There's different parties claiming ownership interest, but there has been no transfer after the fact, so the facts are still the same.
You're losing, I mean, now you're losing.
Okay.
If your parties are basically saying, we should have been the beneficiary.
Sure.
And we should have been, the trustee's deed should have come to us. So as part of the challenge to the trustee sale, when the trustee sale is challenged, why didn't you take action to say, listen, we think the trustee sale was great, but the deed of trust has to be changed?
Well, and that's why we have this lawsuit right now. Back in 2010, after it happened, we tried to get it resolved with, Foundation's commercial transferring title over to us. They didn't do it. That's what sprung out of this lawsuit. So that's how that happened. But there wasn't an objection to the trustee sale before it happened because they didn't object to it. The trustee sale should have happened. It was the deed after the fact that was the problem.
But the trustee's sale clearly indicated that the beneficiary of the deed of trust was Foundations.
The trustee sale notice, or are you talking?
Yes. I mean, the deed of trust
Sure.
named one beneficiary. And when the trustee's deed issued, it issued by the trustee from the trustor to the single beneficiary that was named in the deed of trust.
But that was no longer the beneficiary, and the trustee knew that because it drafted up the assignments. And so that's where we're claiming that we were the beneficiary at that time, and that's why there was a mistake, and it should have went to us.
Understand that?
So that is, in the end around,
Is it significant that the trustee drafted up the assignments, as you just said, if I heard you correctly?
it may be later on, depending on the court's ruling, but we believe that as a matter of law, we have a right to assert a claim and an interest in that property.
But that all rises and falls on the trustee sale.
Well, it starts with the assignments, then it goes to on a litigated issue, yes.
I'm quiet title, yes. Okay.
Yes.
These were individual contracts, but I believe you've helped me understand that together they constitute a whole. Maybe Foundation still has one share, so to speak.
Yes.
Do the documents reference each other?
Do the assignments reference each other?
Yes.
I don't believe that they reference the other 16 assignments. They're individual assignments saying you get a pro rata interest in whatever you invested because there are different investment amounts.
Okay. All right. Thank you very much. Mr. Willenchik?
I'll be brief, as I say. The issue today is whether a party with at most an interest in a security instrument, a deed of trust in this case, who did not issue the trustee sale, did not get title as a result of the trustee sale, put anyone else on notice of their interest in the deed or the deed of trust, the deed that resulted from the sale, can claim an interest in the deed that issues from that sale by FC in this case. And the answer is no. The answer is that they may have a claim against FC from what I just heard. They may be pursuing that claim. They may have already gotten a default against FC for all I know because we're not involved still in the litigation. That's a claim, as I heard it today articulated, between them and FC. If FC, in fact, failed to note them on the sale, then where were they? Why didn't they do anything about that to protect themselves? We couldn't do anything before the sale, I want to make this clear, because we did not have any reason in terms of the actual sale itself to do anything until after the sale, because the basis of our setting aside the sale was the improper fact that we weren't noticed of the sale date and it was done on a holiday. The only way you could set aside that and get the default judgment then that we got against FC would be after the sale, not before it, because we wouldn't have any reason to contest that.
Counsel, your only basis, is this correct? The only standing you had in regard to the sale was the propriety of the sale itself, not the downstream effect if the sale occurred as to who the beneficiaries might be.
Correct, because we didn't know about them. That's the whole point of this case, I guess, and the point of law.
And the deed of trust wasn't.
They never made a peep.
If you refer to them as FC, I think we refer to them fairly consistently as foundations, but
Yeah.
Whatever foundations did or didn't do
Right.
was up to them. We clearly know the Metcalf case stands as one, I believe, where it can become attenuated. But your standing didn't go to, hey, wait a minute, you don't have the right to take my deed of trust and share it with somebody. Your right was to say you had no right to proceed because we never got the money that we were supposed to get before the deed of trust was ever recorded. Is that correct?
Not really, Judge. That was one of the bases.
One of the bases.
The real reason to set aside a sale, though, after the fact, which I think strictly be limited to whether or not the sale was properly noticed. Otherwise, if it were properly noticed, we probably would have, under the case law, have to have done something prior to the sale. But in this unique situation where the sale was conducted on a holiday where you can't do it, and it was admitted by FC's attorney, Foundation's attorney, that they couldn't do it, and also he perpetually continued the sales without public notice. So there was no notice to our client, and that's why the court independently, notwithstanding it was a default, has to still look at it and do justice. And the court agreed, I suppose, which I think it has to, that the only time we could have raised that issue, since we had no notice of the actual sale date, was afterwards. And that's why the court issued the judgment against Foundations, holding that basically the sale was void. If it's void, as was stated, you only have to assign what you have to assign. You don't have anything more to assign than what you have. And they had nothing, essentially. That's what the finding of the court is. And to now try to collaterally attack that, think about this for a second, would be just a complete chaos in the records. I mean, you would have an inconsistent judgment of record. People relying on the title would have an inconsistent judgment saying that the deed and a deed of trust that resulted is void, as well as the final deed, to Foundations. But at the same time, if they were to succeed here, would argue that somehow that was resurrected and now they're somehow in title. I don't know how you reconcile those two, but I do think this court has to give deference, not just deference. I think the court has to follow a judgment that was never appealed. And I disagree with counsel strenuously. They were involved in this litigation. They knew exactly what was going on. They did absolutely nothing to contest that default judgment whatsoever. And they had that ability to do that and to make this an issue, but they failed to do it, just like they failed to step in and become the trustee beneficiary, as they now call themselves, at the time of the sale. And that's important because in the Vasquez case, while I'm on that, in the Vasquez case that they tried to argue is important, in that case, Deutsche Bank, to my recollection, who received the assignment from Saxon Mortgage or whatever, actually did, with Saxon's consent, place itself into the position of being the trustee beneficiary with Saxon's consent, which here, I don't know whether FC Foundations ever agreed or didn't agree to this position they're taking at all. But in that case, it's clear that the assignor agreed that Deutsche could be the trustee, and more importantly, the title could then vest in Deutsche Bank, which gave it the right, although it never brought a quiet title action, in that case, that was brought by the trustor. But so it's not really totally on point, the case they cite. But having said that, it's pretty obvious that what the court there had to be saying was, look, in terms of the law of real property, when a deed issues from a trustee sale under 33-811, it's conclusive. It has to be, because people rely on these things in the chains of title. They rely on the records, as you all know, to conduct real estate transactions. It's almost a sacrosanct principle. That's why we have our recording and notice statutes. The fact that they, in that case, were, in fact, the trustee issuing the sale and therefore obtained the title, to me is a critical fact apparently lost on the appellant or appellants. And that's what gave the interest in title. They have no interest in title by virtue of an assignment of a security interest. Can you imagine if everybody who had an assignment of a security interest, investors in Bank of America, just to be clear on this, made a claim that somehow they had an assignment of an interest in the bank's proceeds as shareholders? Not too far-fetched. And that they came in later to upset a title, arguing that somehow they're the real beneficiary of this deed of trust under the deed, as well as a deed of trust and subsequent trustee's deed that issues from the sale, and turn the entire world of real estate topsy-turvy. That's what we're talking about. Not exactly, of course, but that's the concept here. You cannot assert an interest in title for purposes of 1101 if you don't have any interest in title. And at most, I said, they have an interest in a secured interest. It doesn't have anything to do with whether they had an interest in the promissory note, which, by the way, I didn't read the assignment to say that, just so we're clear on that. I don't remember it, and I'll stand corrected if I'm wrong, but I remember the assignment off the top of my head saying that it was an assignment of proceeds, not of the promissory note. So what we've got, and also of a beneficial interest, but again, that beneficial interest at best could only be in a security instrument, the deed of trust, which in no way, no how has ever been held to give you an interest in title to bring a quiet title action.
If Foundations had assigned its beneficial interest in total 100% in one assignment, would that assignee have an interest in title?
Absolutely not. Unless it,
Does Foundations have an interest in title?
absolutely. It was, in fact, the stated beneficiary under the loan documents and also became the trustee, and that's without question in this case.
Is it,
And so it issued the sale, the title vested in FC, Foundations. That's the whole point. What they're doing is trying to collaterally attack this title that is of somebody that they dealt with, who they could have gone to, to be clear, could have gone to and said, you know what, we want to be the trustee like in Vasquez. You need to assign over not just this beneficial interest somehow, but we need to be the trustee and get title.
well, doesn't that all assume that the more than $2.5 million was lent? I mean, at least my understanding was. Now,
Oh, yeah,
if
I
I'm wrong,
understand.
my understanding was the deed of trust was not to become effective unless at
Yeah,
least
that's correct.
$2.5 million was spent. And-
Or was not to be recorded?
Well,
Yeah, I understand your point, yes. Yeah, that's a good point. That's absolutely correct. But I think in all honesty, I didn't really argue that because the fact of the matter is, I mean, you could certainly find that, but I didn't argue it only because we have the judgment now finding the whole thing to be void,
Right,
so.
but I mean, but
yeah.
even if that was somehow attacked, the next step would have been, the next layer to this would have been.
Absolutely.
Okay, the deed of trust was not to be, am I right, not to become effective?
That's correct.
And the notice of the deed of trust, notice of sale, shows 1.785 million to be.
Correct.
Had been lent. Original principal balance, 1.785 million. And this is on a motion, putting aside the full judgment for a second, this is on a motion to dismiss. The motion to dismiss says, the complaint says, that led to the judgment that's on appeal, said in excess of 1.75 million
Correct.
was lent, but the trustee sale, which is a recorded document, the notice of trustee sale, says 1.785 million. And
Yes.
And so even under that, the deed of trust wouldn't have been.
Yeah, let me add to that even. I believe, and I'll stand again corrected because I don't have a photographic memory, but I believe that when we did go in for the default, that is one of the bases that we considered, of course, which is the fact, and I think the judge ruled that the deed of trust initially, ab initio, was void for that same reason.
All it said was,
Yeah.
it is judged and decreed, and I didn't look at the minute entry, but the default judgment said, prepared by your firm,
Yeah,
says it is ordered, judged, and decreed that Foundations never held a valid deed of trust.
yeah, exactly. But that's the basis for it, to get to your question, Your Honor, which is that it never came into fruition to begin with. So you're right. If this even had gone any further, it had a short shelf life. And the part I don't understand, to be candid, is the complaint here is against Foundations Commercial. So all I hear repeatedly, with all due respect to counsel, is that, we got screwed over by Foundations Commercial. They didn't protect our interest. They didn't give us the assignment of any proceeds. They didn't do this and that. And I appreciate that, and I understand it, but that is a claim against Foundations Commercial, which is extant.
And one of your parties representing is RDP,
Yeah, I think we're representing everyone, Your Honor.
or the appellee?
Yeah,
So the same thing we talked about with your opposing counsel would go for you too. I mean,
Oh, yeah.
We really need to get clarification of what happened in the bankruptcy so we know whether we can proceed with this or whether we should order
yeah.
the parties to go to the bankruptcy court and clarify this.
Yeah, I do tend to agree, frankly, with what counsel said, and also I do agree that there was an assignment, but I understand your point. I had considered it, actually.
I don't want to stand, you just don't step
Yeah.
on the toes of a bankruptcy court.
Understood. Yeah, I apologize. It was something that, frankly, I just didn't even consider, but I understand it's important for you.
Counsel, can we ask you to flesh
yeah.
out a little bit? You had commented on the fact that something that opposing counsel clearly disagrees with you on, that simply by being assignee, they don't go on the deed of trust as a beneficiary. They don't become a beneficiary automatically by virtue of an assignment. You've said you've already said that the assignment in and of itself doesn't make them beneficiaries to do that.
Doesn't give them title.
Do you then agree that it makes them a lienor in regard to their
Yes.
percentage?
They may be, but the fact is that would be on any proceeds received by foundations. And there's a case that we cited to the court. I think you know it, but you know, there's a bunch of cases really, but there's one in particular, if I can put my hand on it real quickly, that basically stated, I don't know why I can't find it real quickly, but it basically stated that lienors and people in that creditors, lienors, do not necessarily have an interest in title for purposes of 121101 to proceed to quiet title. And that's really where this is. It's cited in our briefs. I just can't find it quickly. And
We got the briefs, we'll find it.
yeah. But, you know, we cited a lot of cases, obviously, but I think the point is that they have to stand on the strength of their title. They have none. FC had title. FC no longer has title. It doesn't matter when it did because it's void, and therefore you only, as I repeat from the beginning, have to give that what you can assign, and they have nothing to assign except zero. So, I mean, the other thing that, as long as I have some time, I might as well waste it, I guess, but, you know, the other thing is, and I'll sit down soon, but the other thing is that, you know, I don't understand how people with and I understand the Vasquez case that they cite, and I've tried to distinguish that just for you, because I don't think it's applicable in that sense. But all Vasquez was saying is that, you know, as I recall it, is that you can't, you don't necessarily have to record under the deed of trust statutes an assignment prior to doing the trustee sale. The problem is they didn't do the trustee sale, and that's where we are. So, I mean, what I don't understand, as I was starting to say, is how someone who holds a secret interest, if you will, that doesn't put anyone on notice of any kind, can come in here now after, in fact, a judgment is rendered against foundations voiding its deed, as well as the deed of trust itself, that it relies on to issue the sale, how they actually can come in here and make a claim to title. Now, are there inequities in this? Of course there may be inequities in this. I concede there are inequities in it. It may leave, in some ways, a result that's not palatable to these folks sitting in court. But I don't think that can be taken out on my client. You know, that's just the reality of it. And we dealt with FC. We did not deal with any of these people. And foundations had every right to do what they were supposed to do and didn't do it. We got stuck in the middle of that as well. Our project was ruined, obviously, because we didn't get funding. And you know, everybody's sort of a victim here. But at the end of the day, I think what the court needs to look at is who had the opportunity here, in reality, to do something about this when you're looking at those equities. As I said, our client couldn't do anything about that sale until after it occurred. They, on the other hand, clearly had to have known that their interest didn't amount to an interest in title, clearly could have come in and asked FC to make them trustee. If FC refused to do that, they clearly could have done something about it and sued and put a list of pendants, you know, forced FC to make them trustees because of the same argument they're making to the court today.
Of course, if 1.75 million was all that was lent, the deed of trust wouldn't have been, it doesn't matter who's trustee, right?
I'm not following you, Judge.
No, I mean, you can only, the deed, if I understand it, the deed of trust is not enforceable until at least 2.5 million.
Right.
So it doesn't matter who's the
You're right.
trustee or who's the beneficiary on the deed of trust, until somebody says, okay, I'm lending you the extra $800,000. The deed of trust can, I guess they could have done that. I guess they could, investors could have come forward and said, here's an extra $800,000. But
You're absolutely correct, in truth. That's why I said it's a moot point.
Let me jump in here for a moment. If FC or foundations had undertaken to assign all of its interests in the property, they could have done so. There'd be a new trustee and a new beneficiary.
Substitution of trustee,
Yeah.
which is what happened in Vasquez.
But you know, how different is it where foundations assigned its rights to repayment of the principal and interest under the loan agreement, its rights of recourse against RDP and the others, your clients,
And they never sued us, by the way.
and its rights to any collateral under the loan agreement between FC and RDP. what else is there? I mean, maybe the magic words weren't used that they're assigning everything, but it sounds like they assigned everything.
Well, no, because what I'm saying is, the key is that when they say interest in collateral, that interest in collateral is no different or greater than an interest in a security instrument that is on the property, which is the only interest that FC had in that regard. So what I'm saying is that that's all fine and dandy that you have a secret interest in the deed of trust as to FC paying you proceeds from whatever they recover when they foreclose, but it's a far different thing than an interest in title for purposes of 12-1101 to assert that you are now somehow magically.
What this language doesn't do, you're arguing, correct me if I'm wrong, is it doesn't convey anything of the legal title owned by the trustee.
Or the interest in that title directly to them and of record, yes. And even if they didn't have to do that under Vasquez, what they did have to do at that point is insert themselves as the trustee for the purpose, I'll make this as clear as I can, for the purpose of having some actual interest in title by virtue of the ultimate trustee's deed in their name that would then give them the standing to assert we have an interest in title. They chose not to do that for whatever reasons, Judge, and I can't speculate on why they all chose to do that, but obviously FC doesn't agree with them because FC went forward with the sale and didn't allow them to. So I'm speculating, of course, but I think it's reasonable inferences to say from what you're asking me that
it's possible FC was putting its own interests ahead of the interests
very
of
possible.
others.
Absolutely. I concede that. Although really, when you get right down to it, what's in it for FC to do that when it has the obligation that they would clearly sue it on immediately if they received any proceeds from their ultimate sale of that property by virtue of their deed to share it with them. So I can't conclude that, to be candid with you, that FC was doing this for some ulterior motive, because you're correct, they did assign the proceeds. The only thing I can conclude from this that would be reasonable, even if this case were to go on, which I don't think it can for the reasons that were articulated before by Judge Kessler, at the end of the day, FC reserved the right to be the trustee and be entitled. And that's all we knew. Now, we never knew of these people. So we can only sue FC that's in title to quiet that title, and all they could do to quiet title was to have an interest in the title, which they don't. They only have a derivative interest from FC, and that's the most they have. That's secret and reserved to them, but they can't enforce that in terms of a quiet title action because they're not entitled, and they have no title and no interest in that title.
Counsel, can you give me one sentence on your position regarding equitable beneficiaries as raised by the appellants, that they are equitable beneficiaries under the deed of trust?
They may be as to foundations commercial, but not as to an innocent third party such as us who has no knowledge of them.
Do you have any authority in Arizona about the existence of an equitable beneficiary to a deed of trust?
Do you have any authority that says they're not equitable?
Said that it exists?
I don't.
Thank you.
Mr. Strevin, we will give you a minute and a half if you, I should have warned you of this perhaps, but if you'd like to undertake a brief rebuttal, we'll extend our time. We do have some obligations we need to get to pretty quickly, though.
No, I'll just be really quick on the blame here seems to, and we have no doubt that Foundations Commercial has issues, and obviously we have claims against them.
Sure.
But that still does not take away the fact that we were assigned an interest in that promissory note, which became an interest in the deed of trust, and so we have a valid claim for seeking title to that property as a result of the trustee sale. Nothing after the trustee sale, there has been no transfer of that property to any innocent third party or anything like that. So the date of that trustee sale in 2010, that's what we're still going off of, saying we should have been named as the owner in the trustee's deed, and the trustee conducted the trustee sale, not the beneficiary. They ran it, and under statute they're allowed to run it. So we have an argument, both equitable and legal, to be on that title, and that's where this all springs from. And so, yes, there's claims against Foundations Commercial, but that's not equitable claims.
Do you agree that only that less than $2.5 million was lent?
Do I agree with that? It's my understanding that issue is disputed. I think it would be in the what my clients lent. I don't know what else was lent. I know what they lent. I don't know what Foundations Commercial lent.
Your complaint says more than 1.75.
Yes, because I know what they lent.
The notice of trustee sale says 1.785 was the original principal. Do you have any So you don't know. You don't know.
No,
one
under
way or the
discovery,
other
we don't
whether-
know what foundations, because we understand that the deed of trust, that there's arguments that shouldn't have even been valid unless there's 2.5 million, but we only know what we lent.
Okay.
So that's where that is, and that's where, for purposes of the Rule 7B, or the Rule 12B6 standard, that would be in our favor.
Okay.
All right.
Thank you.
Well, thank you both very much. We'll take the matter under advisement and issue a decision in due course. Thank you.
Thank you,